I'm Ben Meiselas from Legal AF, joined by our co-host, of course, Karen Friedman Agnifilo. We are going to break down some additional removals of redactions on the initial search warrant, and specifically the declaration attached to the search warrant, the affidavit that enabled the Department of Justice to get the search warrant that was executed at Mar-a-Lago, where a probable cause determination was reached on August 5th of 2022. The actual search warrant was executed on August 8th of 2022. You may recall Magistrate Judge Bruce Reinhart. And why are we talking about a magistrate judge? Because magistrate judges are the judges in federal courts who make the probable cause determinations to sign off on search warrants and that ultimately are executed. You'll recall Judge Bruce Reinhart was the judge that signed off on this search warrant. He's from the Southern District of Florida. Initially, a group of media interveners back in 2022 requested that some of the redactions, because it was essentially entirely filed under seal, of the search warrant affidavit be removed so that the public could have access to portions of it. Magistrate Judge Reinhart back in August of 2022 made a ruling saying that some of the information could be released to the public given the historic nature of this case and the importance to the public, but lots of it would have to remain under seal, meaning redacted, and you couldn't see it. And then these media interveners made another motion regarding the same search warrant affidavit fairly recently, in light of the fact that a criminal case has been brought, of course, against Donald Trump for the underlying crimes where probable cause was found. And the media interveners are like, well, now that there's a criminal case, we should have access to additional information in the search warrant affidavit. Unredact some of the other redactions so we can see it. The government ultimately said, sure, there are additional portions that should be made public. Actually, media, we agree with you. We're not going to unredact the entire thing because we still need to protect sources and methods. And ultimately, I think the government did here the smart move. Rather than just saying no, they came back and said, Judge, here's what we think could be unredacted. The other stuff should remain redacted under seal so the public can't see it to protect sources and methods. The judge agreed, signed off on it. And now we saw additional portions of this search warrant affidavit that was used in the execution of the search warrant at Mar-a-Lago, where these thousands of government records and classified records and sensitive top secret information and sensitive compartmented information was found. And I think that there is a lot of big findings here. I think we've learned a lot more information about the diligence, but I want to get your take first, Karen Friedman Agnifilo, about what we have learned now that these additional portions of the search warrant affidavit have been unredacted.
Yeah, so just to remind everybody, to get a search warrant, a prosecutor has to bring someone from law enforcement before a judge, and they have to swear under oath normally it's a document, but in an emergency you can do it orally. But normally it's a document, and the document has two parts to it: the affidavit and the search warrant. And the search warrant is the court order that says, I judge find that the government has proven that there is probable cause to believe that either a crime was committed or that evidence of a crime can be found either on a particular person or at a specific location. And therefore, I authorize the government to go and search for that evidence, that person, that information, basically they can go do that. And that's what a warrant is. And normally if a search warrant is executed, that's all you see is the actual physical warrant. That's all you're entitled to see. If you're a defendant or if you're a premises owner, you're entitled to see the actual warrant that spells out what law enforcement can search for. But what accompanies that is a search warrant affidavit, and that occurs in every case as well. And that's something that normally nobody gets to see. And that is turned over in discovery later if there's a prosecution. But again, as you just perfectly described, subject to redactions. So in this particular case, however, we got to see the affidavit portion, the part that we don't normally see, much earlier. However, it was significantly redacted. Now, the way they did this affidavit, it's approximately 40 pages long. And the way the judge redacted it was, first of all, we don't know which law enforcement officer that's redacted out swore under oath the following information, right? But it then says it gives an introduction, and that was allowed to go in there. This general introduction about the government conducting an investigation regarding the improper removal and storage of classified information, and it talks generally about what was given over and what still remains there. It also gives the address of Mar-a-Lago as the premises to be searched, and they refer to him as F. POTUS, so former president of the United States. And so it goes on for several pages with very little redactions. After they talked about kind of the general facts, they talked about the source of the evidence is very limited, but it's from witnesses and other things that this person obtained through their investigation. And then it talks about, again, very general information about who can search and what, sensitive compartmental information is, and, just general, what is FISA, the Foreign Intelligence Surveillance Act, what is classified information that's not releasable, very general things, basically having nothing to do with this case, right? Then it gets down and it talks about kind of what you're allowed to do and who's allowed to do it with classified documents and materials. But then they get to the section where they have to establish probable cause. And that's always one of the things that law enforcement has to do in a search warrant affidavit. They have to spell out that there is probable cause that either a crime occurred or that there's evidence of a crime. And so they allowed that in up to page 26 when it's just about to get good. Popak said it earlier in a different recording. He said, right when you're about to get to the part where you really want to read it, it's blacked out. And we're talking, lines and lines and lines and lines of it being blacked out. Paragraphs 26, for example, is 100% blacked out. Paragraph 27 is 100% blacked out. And paragraph 28 was 100% blacked out. But they released one more sentence in paragraph 28. It was the former president's practice to store accumulated documents in boxes. And that continues to be his practice. Okay. That was something that they thought they needed to keep redacted, but they were able to unredact that. Then we get to paragraph 34. It says between January 21st and August 2021, the boxes were stored in at least 2 different rooms within the premises, Mar-a-Lago. Then in paragraph 35, they release the door to the storage room was painted gold, the gold door, and had no other markings on it. The door to the storage room is located approximately midway up the wall and is reachable by several wooden stairs. In addition to the approximately 85 to 95 boxes located in the storage room, there were also other boxes in the storage room with merchandise, such as challenge coins, garment bags, memorabilia from Mar-a-Lago, such as photos, frames, and other decor. I found this paragraph slightly shocking, not the gold door part, although that did make me chuckle a little bit. But it's kind of shocking. First of all, if this was a bad movie, you would expect the gold door to have, the secret documents behind it. But just the fact that he stored them along with merchandise and garment bags and memorabilia and challenge coins, and things like that from Mar-a-Lago. I mean, the idea that people are going to go in there looking in. It's a storage room. It's not a skiff, which is secure. It's not locked. This is a storage room with a gold door, a shiny gold door, basically saying, come in and pick up your merchandise at Mar-a-Lago. So, I find that kind of shocking, just the way he treated our classified and national defense information. Then it goes on, paragraph 39. They talk about Pine Hall is the anteroom to the president's personal residential suite. Pine Hall must be the name of a room that they searched or that was significant, but they were keeping that secret, but they released that. And then paragraph 46, it says the purpose of the photograph was to show the former president of the United States the volume of boxes that remained in the storage room. The storage photo, which appears below, captures approximately 61 of his boxes located in the storage room. I mean, just, that was, again, just kind of stunning, just the sheer volume of what he kept there. And again, we knew it, but at least they explained the purpose for which that they did it. Then paragraph 48 says, I believe the contents of the remainder of the former president's boxes are similar to the contents of the 15 boxes, further based on the presence and number of documents and records bearing classification markings discovered within the 15 boxes provided to the National Archives. There's reason to believe that the remaining boxes from which the 15 boxes were taken contained classified national defense information. So, and then it says, following the provision of the 15 boxes to the National Archives, remaining president's boxes were moved from the storage room to other locations on the premises. So this was the part, I don't know about you, Ben, but this is the part that I thought was the most damning, and the most revelatory in here, just the level of detail that they have regarding moving the boxes. So you get down to paragraph 56. There's a portion that was unredacted, that talked about considering that only 15 boxes had been provided to archives of the approximately 85 to 95 boxes that were in the storage room. It appears that approximately 15 to 30 of the boxes had previously been relocated elsewhere. The FBI agents also observed that the composition of the boxes differed, such that fewer banker boxes were visible while more plain cardboard boxes and storage bins were present. It was just interesting how, different types of boxes, were kept there. And how they moved the boxes, and that this was information that was in the affidavit to the search warrant. So a couple other things were in there that has been unredacted. Okay, one of them, the title above paragraph 62 says, surveillance camera footage shows boxes being removed from the storage room area prior to the former president's counsel number one's review in connection with the subpoena. So don't forget, we know that this counsel number one is Evan Corcoran, and Evan Corcoran, based on camera footage, okay, they know the date that Evan Corcoran went in to review the to see, to go through and find classified documents or national, defense information. And based on surveillance footage, they know that boxes were removed prior to that. And so upon review and of course we all know that now, but they knew that prior to executing the search warrant. I mean, this is like the most probable cause I've ever seen. This is so much probable cause, right? Like this search warrant is, I think, beyond reproach. So paragraph 64 says, upon review of the hard drive, the FBI determined that the drive contained video footage from 4 cameras in the basement of the premises in which the door to the storage room is located. The footage on the drive begins April 23rd, 2022 and ends June 24th, 2022. The recording feature of the cameras appeared to be motion activated. So the footage is only captured when it's motion detected in the camera view. One camera in particular, identified on the hard drive as South Tunnel Liquor, provides a view of entry and exit into a room, hereinafter the anteroom, that leads to the storage room. So the doorway itself is not visible to the camera as a refrigerator is directly there. But the footage from this camera nonetheless establishes entry and exit into the room because it appears that it's apparent that when persons within the camera's field view turn directly behind the refrigerator and then disappear from view. So the anteroom, in addition to the entrance from the south tunnel, has approximately 4 doors leading off of it, one of which is the gold painted door that leads to the storage room. The anteroom provides the only entrance to the storage room. However, other offices can also be identified from them and from the surveillance camera footage. And by reviewing the footage provided by the Trump Organization, the FBI has determined on May 24th, 2022, witness number 5 is observed exiting the anteroom doorway with 3 boxes. Then on May 30th, 2022, 4 days after witness 5's interview with the FBI, I mean, this has got to be Walt Nauta, right, Ben? Witness number 5?
Witness number 5 is definitely Walt Nauta.
That's what I thought.
And you see that they were speaking to Walt Nauta as early as May. That's when Walt Nauta was lying to them and saying that, what boxes? I don't know anything about boxes. Yeah, don't know what you're talking about. And then he's seen on the video camera moving the boxes. That's probably the most damning thing at all.
Agreed.
When you talk about culpability, because Nauta originally said, I don't even know what you're talking about. And then to see him moving these boxes, that was a game changer. And we know that in the ultimate indictment that was filed, but that was previously redacted in the search warrant affidavit.
Yeah. Okay. That's what I thought too. I thought this was, absolutely. I think this is partly putting pressure on Walt Nauta to cooperate. Right now, everybody knows what you just said. I mean, think about it. What Walt Nauta is observed, okay, on May 24th, 2022. Exiting this anteroom doorway with 3 boxes, right? And then 6 days later, which is 4 days after he spoke with the FBI, and which telling him that there was significant questioning regarding the boxes, he's observed exiting the anteroom doorway with approximately 50 bankers' boxes. Okay, 50, consistent with the description of the former president's boxes. The FBI did not observe this quantity of boxes being returned to the storage room through the anteroom entrance in its review of the footage. The next day, June 1st, 2022, Walt Nauta, witness number 5, is observed carrying 11 brown cardboard boxes out the anteroom entrance. 1 box did not have a lid on it and appeared to contain papers. The day after that, June 2nd, he's observed moving 25 to 30 boxes, some of which were brown cardboard boxes, others of which were bankers' boxes. Okay. And then he goes on about how witness number 5, Walt Nauta, is observed, 3.5 hours later, observed escorting the president in through the entrance of the anteroom, and Evan Corcoran, the counsel, is not observed leaving until approximately 2.5 hours later. On June 3rd, 2022, President's counsel number 1, Evan Corcoran, is escorted through the anteroom entrance by an unidentified individual wearing a jacket, United States Secret Service Police, printed on the back. The unidentified individual, the former president's counsel, exit the anteroom entrance moments later, and the counsel appeared to be carrying a red-welled envelope after exiting the anteroom. To me, that section is the most significant section of what was redacted. I mean, it just really goes to show how strong not only the cases against Walt Nauta, but just the connection between him and Trump, and just how he is so doing Trump's bidding, carrying all these boxes by himself, escorting the president. I mean, he is really, this guy's in a lot of trouble, but he is really connected to him, and Trump is keeping him close still, right? Going out and having Philly cheesesteaks with him, et cetera. I mean, Trump is keeping this guy close because he does not want him to flip against him, because look at this evidence. I mean, this is crazy, right?
Walt Nauta is going down. And when you see what's there on page 67, and then you go, paragraph 67, and then you go to paragraphs 77 and 78, newly unredacted as well. And this shows that before the search warrant was executed on Mar-a-Lago, the FBI and DOJ knew that more than half, between 34 and 39 of approximately 64 of the boxes that had been removed and what he just talked about had not been returned. So it was basic math. And so ultimately, when you had the situation where the Department of Justice showed up, just frame this in your mind. The Department of Justice, they sent a subpoena out in May. There's an extension request by Trump's lawyers, but then Trump's lawyers, Evan Corcoran thinks that he's searching, I think, the right place. He's not searching anywhere else. When he meets with the Department of Justice and the top counterintelligence officials on June 3rd, the DOJ knows all of this, right? At this point, the DOJ is aware during this meeting that Evan Corcoran is lying to them, and they are aware of a lot of the misconduct that is taking place. And so there's a disparity of information because Trump's not telling his own lawyers what's going on. And so some of this was learned a little bit later through the surveillance footage, but the DOJ is coming in with knowledge, and Trump throwing his lawyer, Evan Corcoran, under the bus, and also Walt Nauta, who's going to be in a lot of trouble.
Yep, absolutely. Absolutely.
And so I think, look, my final point, and if you want to give a final summation on these redactions that have been removed, is it shows very clearly that at every step of the way, Donald Trump knew what he was doing. He knew what he was doing. He was giving the middle finger to the law, to the Department of Justice. These were his brain documents, or whatever they call it, whatever they were calling it. These were his things. He wasn't going to give them back. He took them. You can't do anything for me. It's malignant narcissism, criminal, someone who doesn't give a crap about our laws. And you're not above the law. And the fact that somebody could read this and then read the indictment and be like, yeah, I'm cool with that. You can do whatever you want to do. Then you can't have a credible argument with me on everything else. You have zero credibility now. Because if there was a similar affidavit as it relates to Hillary Clinton or Biden or Pence, if there was this level of culpability and intent, we're in an evidence-based system. It's not about conjecture. It's not, Donald Trump did bad things, let's not like him, No, there's evidence. There's data, there's facts, there's photos, there's videos, there's statements. That's what a case is about. It's not about Kevin McCarthy and Jim Jordan making something up and then trying to find and fabricate evidence that justifies the defamatory statements that they make. No. This is evidence. This is statements. This is the stuff you dealt with as a former prosecutor. Karen, you get the final word.
Yeah, and in addition to what you were saying about, Donald Trump thinks these were his documents, that he could keep up, that he could declassify them, and there's a lot of people who agree with that and believe that. Even if, putting that aside, even if you buy that, right, if he thinks there's some gray area and everybody does it, whatever, the way he kept this, any other normal, rational person would put this in a safe, a locked safe. They would guard this with the absolute utmost care, because these are our nation's most incredibly sensitive documents that exist. They just are. And they are so sensitive that it can put our country at risk. It can put people's lives at risk. And the fact that he thinks they were his, he thinks he can do what he wants with them, but just the carelessness and willy-nilly way that he kept the documents in these rooms that were accessible to many people, to other people, to just general people. That one room had 4 doors to it. It has a painted gold door. I mean, it's just absolutely, that they were open. One of them's the liquor, camera, because I guess that's where they keep the liquor. And the other room is the merchandise, where they keep the challenge, the Mar-a-Lago challenge coins, whatever the stuff that they have that they give away. I just, that's how he keeps our most sensitive, secret information. To me, shows he's not fit to lead this country. He's just not. I mean, that's what, to me, this is so the difference between, again, I don't agree at all with him that he could keep these or that he should be able to keep these, et cetera. That's totally awful, and he can't. But he did it intentionally. And, he, like all the other people, Biden, Hillary, Pence, all the other people who had it, they didn't realize they had it. They had no idea. And the minute they found it, they gave it back. It's like a hot potato. You don't keep this in your hand. You don't keep this somewhere. He not only took it intentionally, but then he kept it in a way that put everyone's lives at risk, not just in this country, but in other countries. To me, that to me just is a different level of culpability. And he absolutely deserves not only to be prosecuted for this, but to be put in prison, and he should never hold office. He is unfit.
Couldn't agree more with you. Always enjoy these hot takes together. Make sure everybody is subscribed to Legal AF wherever you get your audio podcasts. All you have to do is search Legal AF. It's free to subscribe. Subscribe to the MeidasTouch YouTube channel. It's free to subscribe. And if you want to support the channel in other ways, check us out at patreon.com/MeidasTouch. Have an incredible day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.